These are the legal strategies and defense tactics you need to know if law enforcement seizes your vehicle over an alleged illegal engine swap. The difference between keeping your car and losing it forever often comes down to understanding your rights and acting within critical timeframes that most people do not even know exist. Let me be clear from the start. Engine swaps themselves are not inherently illegal. The legality depends entirely on how the swap is executed and whether it complies with emissions regulations. Under the Clean Air Act, the core principle is simple. When you perform an engine swap, the new engine must not pollute more than the original engine. This means the newly installed engine must be the same year or newer than the vehicle, and all emissions controls must be installed and functional. But here's where things get complicated. Federal penalties for tampering with emissions control systems can reach $5,580 per non-compliant part per day, and these amounts can easily exceed $50,000 for a single modified vehicle. In California, penalties reach $25,000 per vehicle under state law, and CARB conducts roadside inspections specifically targeting modification shops. The enforcement landscape has shifted dramatically in recent years. Since 2020, the EPA has ramped up its national compliance initiative to stop aftermarket defeat devices. Over 170 civil enforcement cases have been finalized, with total penalties reaching $55,050,000. At least 17 criminal cases have included $5,060,000 in fines and 54 months of collective incarceration. These are not just statistics, they represent real people who lost real vehicles. Consider the case of Rudy's Performance Parts Incorporated and owner Aaron Rudolph, who pleaded guilty and agreed to pay $10 million in criminal fines and civil penalties for manufacturing and selling emissions defeat devices. Or PPEI and Corey Willis, who were ordered to pay $1,550,000 in criminal fines, plus $1,550,000 in civil penalties in December 2024. A New York dealer who specializes in diesel pickup trucks was fined $50,000 and sentenced to 4 years of probation for deleting emissions systems. But here's a crucial development that changes everything. In 2026, the Department of Justice announced it would no longer pursue criminal charges for tampering cases under the Clean Air Act. As a result, DOJ is now dismissing existing criminal tampering cases, more than a dozen prosecutions so far, and this decision may impact some 20 or more ongoing investigations. However, and this is critical, DOJ has signaled its intent to continue civil enforcement, meaning you can still face massive financial penalties even without criminal charges. Now, let's talk about the elephant in the room: civil forfeiture. This is how law enforcement can seize your vehicle even if you are never charged with a crime. The proceeds from these seizures have grown explosively, from $93.07 million in 1986 to over $2 billion annually by 2019. As Senator Cory Booker explained, civil asset forfeiture allows federal law enforcement to seize the property of Americans who have not even been charged with or convicted of a crime. Under this system, police can keep cash, cars, and even homes based on mere suspicion of a crime. If your vehicle gets seized, you have exactly 7 days to file a motion to recover it during litigation. Miss this window, and your path to getting your car back becomes exponentially more difficult. In some states, if you do not make a demand for return within 90 days after the termination of any criminal proceeding, your vehicle is deemed abandoned. Here's your defense playbook if your vehicle is seized. First, contact a criminal defense attorney immediately. Not tomorrow, not next week. Timing is absolutely critical. Your strongest defense is often a Fourth Amendment challenge. Your attorney will examine whether police conducted a lawful traffic stop, whether the search of your vehicle violated your constitutional rights, and whether the seizure itself followed proper procedures. The Supreme Court interprets the Fourth Amendment to mean that evidence obtained from an illegal vehicle search cannot be used in court. This is the exclusionary rule. The innocent owner defense is another powerful tool. To use this defense successfully, you must show that you had no knowledge of any crime or that you took reasonable steps to prevent illegal use of your vehicle. This defense can be pivotal in regaining possession of your seized vehicle, especially if someone else was driving when the alleged violation occurred. Documentation is your lifeline. Keep all records, including seller messages, repair invoices, photos, and service history. Gather documents that prove your ownership, such as titles and registration papers, and keep any correspondence with the federal agency involved in the seizure. If you cannot prove legitimate ownership and compliance efforts, you will be fighting an uphill battle. Let's address the distinction between legal and illegal swaps. A VIN swap is always illegal under federal law. Any intentional removal, alteration, or replacement of a vehicle identification number is treated as a felony under Title 18, Section 511. By contrast, engine swaps that are properly documented and compliant are legal. In California, which has the strictest standards, here is how to make your swap legal. Use an engine that is the same year or newer than your vehicle, retain all original emissions equipment, and complete a referee inspection. The referee inspection costs less than $40 and can approve your engine change based on a visual inspection if everything is compliant. One California expert noted that inspectors see Fords, Chryslers, Datsuns, and many other makes, so they cannot be expected to be an expert on every vehicle's smog equipment, unless it is a Volkswagen. Here is a practical tip. When you call to make an appointment at a California referee station, say engine change, not engine swap or V8 conversion. The person on the phone may not understand the latter terms. The regulatory environment constantly evolves. In July 2021, CARB changed the scope of smog tests to include testing whether a vehicle's engine control module has been changed beyond original equipment manufacturer settings. Multiple enforcement cases now originate from social media content, showing non-compliant modifications with identifying information visible on Instagram, TikTok, and YouTube. There has been significant pushback from the automotive enthusiast community. From 2016 through 2022, SEMA advocated for the RPM Act, a bipartisan bill designed to protect Americans' rights to modify street vehicles into racing vehicles. Despite having over 165 lawmakers co-sponsor the legislation, it ultimately failed to pass. SEMA President Mike Spagnola said, "We would not have made it this far without this incredible effort by so many of our members." The civil forfeiture landscape is slowly improving. Since 2014, 37 states and the District of Columbia have reformed their civil forfeiture laws. 16 states now require a conviction in criminal court to forfeit most or all types of property in civil court. Kansas passed comprehensive reform in 2024 with SB 458, which increases the burden of proof for seizures, requires judicial review to establish probable cause, and mandates the government to pay attorney fees if a civilian successfully challenges the seizure. Prevention remains your best strategy. Document everything meticulously. Use engines that are the same year or newer than your vehicle. Maintain all original emissions equipment. Obtain CARB executive orders for aftermarket parts where applicable. Complete required inspections. Update titles and registration to reflect engine changes. Keep bills of sale for replacement motors and document donor vehicle sources. The bottom line is this. Engine swaps can be completely legal when done properly, but the consequences of non-compliance are severe and growing. With civil penalties reaching tens of thousands of dollars per vehicle and the threat of permanent vehicle seizure. Understanding your rights and following proper procedures is not optional, it is essential. The 7-day window to file motions, the innocent owner defense, and Fourth Amendment protections can save your vehicle, but only if you know they exist and act quickly when seizure occurs.